Everything is correct. What's the issue? Network? It's not coming there. No shared content. No shared content. Why it's not coming here? Hmm? No, but it's not showing. No? It's done? Okay. Hello, everyone. Very good afternoon. How are you all, champs? After a long time? Yes? Okay. So today we are going to start contract law, which we had covered half of the portion. Yes, online buddies join soon. And another 2 lectures probably we can cover the contract law. Okay. So last time we had started with discharge or termination of contracts. There I had left you. Okay. So yes, this is CS Aarti Panigrahi, your mentor for the business law and management, and I am directly live from the heritage city, Mysuru. Yes. So guys, discharge or termination of contracts, the last time we were taking up, where we had seen the performance of contracts. After the performance of contract, you can discharge the contract. Okay. Then tender of performance. Who can demand performance? Effect of refusal to perform wholly. Section 39. We had covered section 40. By whom must a contract be performed? Devolution of joint liabilities. Important section, guys. There they can ask you little bit tricky questions. Okay. Section 42 to 44. Then right of promisee. We had done release of joint promisor, devolution of joint rights, and discharge by mutual agreement or consent. So today we are going to start by discharge by mutual agreement or consent. Means if 2 parties are telling that we don't want to continue this contract, so they can discharge it by their own, both the parties consent. Are you getting consent? If they are telling we don't want to take it further, so they can discharge it. Okay. So section 62 and 63. A contract may be discharged when all parties mutually agree to terminate. Mutual agreement is, mutual consent is important, guys. Okay. Mutually agree to terminate or modify. Either they will terminate or modify or replace their existing contractual obligation. How it will be there? Okay. Either they will terminate completely or they will do any kind of modification both parties need. They can bring that modification, or they can replace the original and they can bring the new contract. Okay. So by their existing contractual obligations. Section 62 and 63 recognize various modes through which a contract can be discharged by consent. So first mode is coming there, novation. Okay. So what is novation? Novation takes place when a new contract is substituted for an existing contract. Means what they are doing here? They are substituting the contract and they are bringing a new contract, guys. New contract. Okay. I have to remember here, novation by the name also you can understand. New contract is substituted for an existing contract. The new contract may be between the same parties or different parties. This you have to remember. The new contract, if the new contract is coming, guys, either the same party can bring a new things, new terms and condition, and what they can do, they can bring any new parties also in that. Okay, so this also you have to remember, either with the same party or or different parties. Once the new contract comes into existence, the original contract is discharged. So when the new contract will come into the scene, the what will happen? Originally framed contract will be discharged. Okay. So that is the novation. By novation, you can discharge the contract. Original contract will be discharged. Then what? Alteration, the modification we had talked. Okay. So alteration refers to a change in one or more material. What is the meaning of material terms, guys? Material terms is what? Monetary? No. Important. Material term. Say suppose you had made contract and there are some 4 or 5 terms and condition. Now some terms and condition are very important to keep that contract. Some are not that important. So the important terms, that is called the material terms. If that important terms are not there, maybe if you are taking a further the contract, there is no use. Uska koi sense nahi banta. Okay. So what you can say, what you have to do, what you are modifying and altering, guys, the material terms of a contract with the consent of all parties. The altered contract replaces the original. So with the modification you are bringing, if you are bringing the changes, and then you cannot keep the original one, you will bring the altered one. Okay. Altered contract. Now rescission and remission. So rescission is what, guys? Rescission means cancellation of contract by mutual agreement of the parties before its performance. You have to remember, when you can do the rescission, guys, before its performance. You can mutually terminate the contract with the mutual consent. Once resigned, neither party remains bound to perform the contract. So before the performance, you can discharge the contract. Remission is what? Remission occurs when a promisee accepts a lesser performance than what was originally promised. Try to understand here. Remission is what? Remission, you can say the concession also, guys. Concession. You are giving a concession. Say suppose A had given his land, A had made a contract with B that you give me 10 lakh rupees and B will give the land. Okay. Yes. B will give the land and A will give how much rupees? 10 lakh rupees. Okay. No, here promisor and promisee. We have to see the promisee. So remission occurs when a promisee. Who is the promisee here, guys? Promisee. Who is promisee? B. So let's change these arrows. Not a difficult task. Shallow. What we'll do? B had told to give land. De raha tha kya? B, yes, 10 lakhs. Who was paying? No, A will pay the 10 lakh rupees. Ruko yaar. Remission occurs when promisee accepts a lesser performance. If this promisee, our B is what? Promisee. And A is what? Promiser. Okay. Now A had told that I will pay you 10 lakh rupees. Okay. And B told I will give you piece of land. I will give you piece of land. Okay. Now the B had told that my land is how much? 10 lakhs worth. Okay. Now A told okay, I will pay 10 lakh rupees. Now later on, they made a contract. Now later on, A is telling I am not able to pay 10 lakh rupees. I am not able to arrange 10 lakh rupees. Can you give me in the 8 or 9 lakhs? Okay. So now B is who? Promisee. So remission occurs when promisee accepts what? Lesser performance. Okay. Yes. So lesser performance than what was originally promised. How much promised, guys? 10 lakhs. But now A will pay how much? 9 lakhs only. And promisee is B. What B will do? Remission. Remit. Okay. So B will do some concession to A that it's okay. I had promised to give you land. You gave me only 8 or 9 lakhs. 8 lakhs or 9 lakhs. We will do this contract. Okay. That is called the remission. Okay. Contract discharged by remission. Okay. So mutual agreement or consent. What is the highlighted point here. These topics are covered under mutual agreement or consent. Okay, na? So here novation, alteration, and rescission. And what is the important thing, guys? In each and every topic, what is important? Mutual agreement and or consent. Otherwise, they cannot discharge their liability or obligation. Okay. So remission, did you get remission? Now waiver. What is the difference in this and that? So for example, acceptance of lesser amount in full settlement of a large debt amounts to be remitted. That can be piece of land of exchange, or if somebody had taken, A had taken 10 lakh rupees loan and A had taken 10 lakh rupees loan and he told to B, I will repay you after 1 year. But now he is not repaying. He is not able to repay. So after 1.5 years, B is telling, okay, let you just pay me 8 lakh rupees and let's settle this debt, like that also. So remission. What is waiver, guys? Yes? Clearing the debt. Waiver is what? You are leaving your contractual right. You are allowing someone to, you are discharging that person from the whole liability. Okay? So waiver means voluntary relinquishment or abandonment of legal right. Now A have to pay 10 lakh rupees to whom? To B. B is our promisee. Okay. Now this legal right, when a party waives a right, when a party waives a right available under the contract, now there is it is not important that any it can be debt or it can be any kind of performance also. Any party, you have not to think only about the promisee, any party. Okay, guys. So any party, a party waives a right available under the contract, the other party is released from the corresponding obligation. Okay. Now B is telling, I will leave all 10 lakh rupees. You are not, say suppose that A become insolvent or anything happened to A. So what we can say, okay, I am waiving all the amount. I am leaving my legal rights. You have not to pay that. That is called the waive. Okay. Yes. So this was by the mutual agreement or consent. And next topic is what? Discharge by lapse of time. Discharge by lapse of time. Okay. So the Limitation Act 1963. The Limitation Act prescribes specific time limits within which legal proceedings must be initiated. So Limitation Act is providing you a reasonable time, that in what time you should go and claim, you should take the help of the court. Say suppose you had given debt to someone, okay, you had given some debt to someone, now you are sleeping 10 years, like okay, he will pay, or yes, hello, what's going on? Focus here. Yes. So what I'm saying, that if a person, a Limitation Act has given the time frame, in this, within this time frame, you should take the help of the law. Now you had given the debt to someone. Now that person is not paying you 4 years, 5 years, 10 years. Then you will go 10 years? No, there is a prescribed time limit. In that limit, you have to go and you can take the help of the law. So in the debt case, 3 years. More than 3 years, if say suppose you had given debt to someone and they are not repaying you, what will happen? You cannot take the help of the court. Court will tell, where were you 3 years? सो रहे थे क्या आप? ठीक है. अगर if they are trying and then they are not succeeding because of the reasonable cause, then again another 3 years. Say suppose 1 year was they had tried, but because of not their fault they are not getting their debt, means another 1 year will be added there. Very good question. Very good, Sharon. So the Limitation Act prescribes specific time limits within which legal proceedings must be initiated. If a party fails to enforce his contractual rights within the prescribed limitation period, he loses his legal remedy. Legal remedy means what? You have a legal right to reach to the court. You can take the legal remedy. Solution. Remedy is what? Solution. Okay. So if that prescribed limit you are crossing as per the Limitation Act, you are not able to take the legal remedy. Okay. Yes. As a result, the contract is effectively discharged by lapse of time. After 3 years, you are not able to claim that. So what will happen? After the 3 years lapse of time, that other person will be discharged. You had given loan to someone 10 lakh rupees and that person is not repaying the loan. Now what is happening? That person is not repaying, you are sleeping 3 years, you are waiting that person will give you. After 3 years, you cannot claim that loan. Okay, na? Yes. So example, if a debtor, he is a person who had taken the loan, debtor fails to repay a loan on the due date, the creditor must generally file a suit within how many years, guys? 3 years. Failure to do so within the limitation period bars the remedy available under the law. Bars means now you will not, you are banned to take the help of the court. Okay, it is the restriction. Restriction. Bars is what? The restriction. The remedy available under law. Okay, yes. Now, discharge by operation of law. So, a contract may also be discharged automatically by operation of law under certain circumstances. Under certain circumstances. So, by merger. Now, merger, do you know merger? Merger is what? Huh? Say suppose A company it's a weak company. Say suppose it's a weak company. It is merging with the B company, strong company. Now these two companies are coming together. It can be called amalgamation. If they are making a new entity C, so merger. Okay. So what happened here? When an inferior contractual right merges into superior legal right, the original contract is discharged. Now what will happen? This A company merge with which company? B company. Okay. Now they are making a C company. Now earlier whatever contracts were there, contracts of A company, original contracts, guys, that will be there or what? No, it will be discharged. Because when an inferior contractual right merges into superior legal right, the original contract is discharged. Because now they are not A. Now they are not A. They are becoming C. What? That will be there. Because if say suppose they are merging into AB or they are making or C. Okay. So the original contract will be discharged. Okay. Even B company contract will be discharged. Merging, because what happened? They are making a new entity. C. Are you getting? If A and B coming to C, now there no original contract will be none. So before before coming to C, they have to discharge all their obligations. It is not simply discharge. You know, when they are going to merge, a merger is not a simple thing like you by your wish you are going and merging with someone. Okay, no, with any company you have to take permission of your shareholders. Are you getting? When you will discharge all you had taken all investment from the shareholder and simply you are making loss in the company and then you are telling I am weak company, I am going to merge with the strong company. What about these creditors, investors? So you have to do all the settlements, then only you will get the merger permission. Are you getting? Yes. So by merger for at this level for you, it's a very small concept they had given. Okay. So the original contract will be discharged if they are coming together by the way of merger. Second, by unauthorized alteration. Now two parties are there, A and B, guys. Okay. Now say suppose A had made some unauthorized, which is not allowed to make alone. So unauthorized alteration, if A is making at the option of B, you can discharge you can resign the contract. Means A is not authorized to change that without taking the permission of B, but A is doing that alteration. So whether B will accept that contract? No. So if a party makes a material alteration, what again? Material alteration. You have to remember it. In a written contract without the consent of other party, A had made many important changes in the contract without taking permission of consent of B. So the contract may be avoided by the aggrieved party. Who is the aggrieved party, guys? B is the aggrieved party. Yes. Unauthorized alteration. Then by insolvency. When a person is adjudged insolvent and the court grants a discharge order. Okay. Now, how the court will discharge? Tell me. When a person is adjudged insolvent, adjudged insolvent is what? A person is by the court. There is a court proceeding against that person that you are insolvent. When the person will become insolvent, when any person will become or any yes, when they are not able to pay their debts, means there will be liability or obligation. Now the court proceeding will start against that person that you are the insolvent. Okay. Now when the court will give the discharge order, when, why the court will give the discharge order to that person? That person have to do something or not? On behalf of that person, somebody will do something or not? Say suppose that person is not able to do, the property of that estate of that insolvent will pay the debt or not by selling that. So court will appoint official liquidator and that liquidator will do the settlement. Okay, then only court will give the discharge order. नहीं तो कोर्ट क्या तुम्हारा चाचा है, अंकल है क्या? अंकल को क्या बोलते हैं कन्नड़ा में? हाँ, चिकप्पा दोडप्पा. हाँ. So yes, so how an insolvent will get the discharge order? After completion of their obligation. Okay. So when a person is getting discharge order from the court, he is released from liabilities relating to debts covered under insolvency proceeding. When he got the discharge order, means he had already done his obligation. That's why. So there will be no liability related to the debt. When, which kind of debt? When court proceedings were there, that time what debt were involved, that he will be discharged by that debt. Okay. So debts covered under insolvency proceedings. Okay. Yes. Any doubt? Any doubt in this? Tomorrow there will be 10. Tomorrow I'll be able to take class on class. So by then in the next class there will be 15 question. हमारा मेगा क्विज रखेंगे. Okay. Yes, contract. Yes, mega quiz in the next class. 15th August. हाँ, मेगा क्विज रखेंगे 15th August. इंडिपेंडेंस डे. ओह, इंडिपेंडेंस डे चाहिए मैम. Okay, we'll see. Fine. Okay, guys. So discharge by operation of law, by merger, unauthorized alteration and insolvency. There we had seen novation, alteration and remission and waiver. Okay. Yes. The next is what? Discharge by impossibility or frustration. Okay. Section 56. Star mark karo. Discharge by impossibility or frustration. A contract may be discharged when performance becomes impossible. Okay. When performance becomes impossible. Section 56 deals with the doctrine of impossibility, commonly known as frustration of contract. Initial impossibility. Okay. An agreement to do an act which is impossible from the very beginning is void ab initio. If you are making such kind of contract which is impossible to start from the beginning only, that kind of contract is called void ab initio. From the beginning it is invalid. Okay. Void ab initio is what? From the beginning it is invalid. Okay. Now example, A agrees to discover treasures through magic. Very good. This was the contract, guys. A agrees to discover treasure through the magic. Is it possible? Huh? Possible? No. Since the act is inherently impossible, the agreement is void from the outset, from the beginning. So this kind of contract is void ab initio. Subsequent or supervening impossibility. Okay. Unexpected impossibility. Fine. Subsequent. Now at the time of doing contract that was possible, right? But later on they had seen that it is impossible. Due to what? Due to disaster also. Okay. If anything happened which is not in your control, that is called the supervening impossibility. Are you getting? Supervene. Now the law of the country changes due to any reason. The law of country changes and you had made a contract and law of country changes That was in your hand? No. So that is called the supervening impossibility. At the time of contract, you were okay. Both parties were okay. Later on, it was difficult to perform due to the changes of law. Are you getting? Yes. So these are called the subsequent. Subsequent is what? After making the contract, further you are seeing that one party or any party is not able to perform that contract. Now, somebody had told to paint a making a painting, means their personal skill is involved in that, and later on that person painter hand is like in accident he lost his hand only. Okay. Oh, true emotions तुम्हारे आगे. Oh, what ma'am, what happened? उसका पैर टूट जाना चाहिए था, हाथ क्यों टूट गया, है ना? Yes. So yes, what? Nalin? You are not a painter, right? Yes. So guys, so what will happen at the time of contract? His both hand was okay. Now after some time, he got an accident and he lost his hand completely. Now he's not able to paint. So whether he can give it to the legal heirs or what? No, na? Yes. So the contract will be discharged by the impossibility. So supervening and subsequent impossibility. Yes. Yes. Fine. That will be there if he will able to. If he will able to do. Now he will say, I don't have my hands. I can't earn for my food. From where I will repay? Circumstances. You have to check the circumstances. Okay. Yes. Yes. So sometimes a contract is valid when made. Okay. What you have to remember? When made, it was valid, but later becomes impossible or unlawful due to circumstances beyond the control of the parties. This you have to remember. Beyond the control of the parties. In such cases, the contract becomes void and stands discharged. Okay. Contract becomes void, invalid, and it stands discharged. Without performance also, it stands discharged. Okay. Example, a singer contract to perform at a concert but subsequently becomes seriously ill and is unable to perform. The contract is discharged due to impossibility of the performance. If that singer is wealthy, he can give or she can give the compensation or any loss suffered by the promisee. So they have to pay. Okay. Any fine what you are asking, Hemant. Okay. So knowledge of impossibility. Now, where the promiser knew, we have done this example, no, right? So the contract will be subsequently become seriously ill and is unable to perform. The contract is discharged due to impossibility of performance. Knowledge of impossibility, where the promiser knew or ought to have known about the impossibility of the performance. Already promiser was aware about it and he was estimating that the impossibility will happen. Then in that case, what will happen? Means already the promiser is knowing about the impossibility. In that case, what will happen, guys? He must compensate the promisee for any resulting loss. Are you getting? Yes. Promiser is already knowing that this kind of unexpected thing can happen. And because of that, I will not able to perform my promise. So in that case, he have to compensate the promisee. Let's take this example. A agrees to sell land to B, knowing that land has already been acquired by the government. How he can sell then? Okay. So A was already knowing that. Okay. He was thinking by chance if I'll get my land. Okay. So he had promised to give to B. Now the agreement is invalid, but A must compensate B for the loss suffered. So these two situations are arising here, guys. When knowledge of impossibility is there, knowledge of impossibility will be there, compensation will be there. Are you getting? When the promiser is knowing that there will be impossibility, then compensation is important. Okay. It will be there. It must be there, compensation, because he was already aware about the impossibility. But where they are not aware about the impossibility, then they will check the circumstances. In what circumstances promiser can repay any kind of compensation or fine. Okay. Yes. That difference you are getting. Yes. Then judicial interpretation in one case, in Satyavrata Ghosh versus Magniram Bangur and Company 1954, the Supreme Court held that the word impossible does not mean only physical impossibility. Okay. It is not mean only physical impossibility. Performance may become impracticable or useless because of the changed circumstances which destroy the very foundation of the contract. As I told you, the circumstances which are not in their control. It is not only physical incapacity, it can be anything. As I told you, changes in the law. Okay, so because of that also what can happen? The contract they are not able to perform. Impossibility will create. So however, temporary difficulty, now this any kind of temporary difficulty, guys, temporary difficulty, not permanent, or inconvenience does not amount to frustration unless it strikes at the root of the contract. Now say suppose A told to build a building for B. Okay. Now A thought in 10 lakhs, in 20 lakh rupees, I can build this building. Okay. And he had taken a contract of 20 lakhs. Now all material, labor, everything who have to give? A have to give. Now he took the contract of 20 lakh rupees. Now, but when he was doing actually, then what happened? His cost is increased. Now he is telling, oh, my cost is going 25 lakhs. How I will give you? I will not perform this. This is not allowed. Are you getting? So further you will see the example. Okay. So the temporary difficulty or inconvenience does now, or you will think, no, I'll become tired of doing this. Say suppose somebody had taken the painting, no, I'll become tired, my hand is paining, I will not do that. These kind of temporary difficulty will not the reason for the, it is not the reason to cancel the contract. Okay, discharge the liability. Okay, unless it strikes at the root of the contract, any kind of changes, any kind of circumstances which is destroying the root of the contract, the major important thing of the contract, till that time you cannot discharge. Okay, so supervening impossibility, a contract may be discharged due to subsequent impossibility in the following situations. Destructions of the subject matter. This you have to remember, guys. First of all, for what is the subject matter of that contract, what is the main object of the contract will destroy, then why you will go for the contract? Okay, yes, without the fault of either party. There is no fault of any party, but because of any circumstances changes, there will be subject matter changes. Say suppose I wanted to purchase a land in Himachal Pradesh. Okay, I had made a contract with someone that I am going to purchase your land, I am going to pay this much of amount to you. Now what happened? Now government brought the rule that outsider of the Himachal, they cannot buy the land. Whose fault is this? Anybody's fault is this? Then the subject matter is only cancelled. Okay, so in that case it will be discharged because of the supervening impossibility. Okay, non-existence or change in the state of affairs, any kind of, as this state of affairs, this what example I had given, you can take this, or say suppose you are in subject matter also, you can take an example like you wanted to start a manufacturing unit. Okay, for that you had done a contract with outside country to bring the technology from there. Now they are telling, we will do the alliances with you, we will become your joint venture, but we will not give you our technology. What was the subject matter of that contract? You wanted to bring their technology. Now they are not ready to give their technology. Whether you will go for that contract? No. Okay. Yes. And the changes of law or any other thing like non-existence, like I had made a contract to buy a land in Himachal Pradesh, but they are telling, no, we are not allowed to outsider. So what will happen? Because of the change in the state of affairs, because of the change in any kind of law, that contract is impossible to perform. Okay, so in that case it will be discharged, stand discharge, of which the contract was based. So what it was based on that law, and that law only changed, then it cannot be happen. Then death or physical incapacity of a person whose personal skill, at painting and all we had discussed earlier, these examples. So personal skill or qualification formed on the basis of the contract. Then yes. So this was about the impossibility. Now we will see the legality, supervening legality we will check. Okay, so discharge by operation of law we had seen here, by merger, unauthorized alteration, and by insolvency. Now, discharge by impossibility or frustration, section 56. Initial impossibility, then subsequent or supervening impossibility. When in there you have to see the supervening impossibility was not earlier they were not aware and they were aware about his knowledge of impossibility. Then what will come there? Compensation must be there. Okay. Then judicial interpretation, one case law we had seen here. Then you had seen here that not only physical impossibility, because of the changes circumstances also there can be impossibility arises. Okay. And the temporary difficulty or inconvenience will not impact to the contract. You cannot get frustrated by the hard work or any other cost involved in that, and you can say, I don't want to perform this contract. Okay. So supervening impossibility, subject matter, if destruction of subject matter, non-existence or changes in the state of affairs, and death or physical incapacity. Okay. Yes, these things they are going to ask you in your exam. Okay. Yes. So discharge by, today only you revise it. Fine. Discharge by supervening illegality. Okay. It was impossibility. Now we will check the supervening illegality. Okay. Where performance become unlawful due to subsequent changes in law or due to an act of competent authority. The contract is discharged. Anything you cannot go, any contract you made that cannot go against the law, that you have to remember. Are you getting? That should, we had seen further also that any contract if you are making that is against the public policy, but against the public policy what act will be covered? Everything is given? No, it is not given. You are even not aware and you are making, and later on we are getting that it is against the policy. You have to resign that contract. The both party will be discharged by that contract. Okay. So nothing you can do against the law, that will become the illegal, guys. Okay. Example, A contracts with B for cutting trees. Okay. Subsequently, a law requires a license for cutting trees and license is refused. Okay. The contract become discharged due to the supervening illegality. Clear? Hai? Now you cannot say that why you are not cutting tree, because that person had applied for the license, it was refused by the government. Now he is unable to perform, means the other promisee cannot force that person to perform. So that person will be discharged by the liability. Okay. Now cases where there is no supervening impossibility. This is more important, guys. More important, cases where there is no supervening impossibility. Okay. The following situation don't discharge a contract. You should know what you have not to do. That is more important than knowing that what you have to do. Yes? Right? Yes. So mere difficulty or increased expenses of performance. I had given you example, no? The cost of the building increased, so that person was refusing. So that will not allow. Okay. So mere difficulty, you are tired by doing some work, you are getting difficulty. No, then you cannot discharge by the liability. Or increased expense of the performance. In these cases, nobody can tell that I don't want to perform my obligation. Mere difficulty or increase expenses of performance. Commercial hardship or reduce profitability. Now you are not getting more profitability, so you will say whatever I promised, I am not going to do that because I thought I will make profit, but I am not able to make. In the process, that person got to know. So reduce profitability or commercial hardship means you are getting difficulty of performing that at the commercial term. So that person is saying, no, it is very difficult for me and I'm not getting more profit, so I will not do that. Are you getting? Yes. Then strikes, lockouts, important it is. Now, strikes, lockouts, civil disturbances or riots, unless the contract specifically provides otherwise. Tell me, what does it mean? Who will tell me? Interpret it. Hmm. Hmm. So the strikes and lockouts will be there, contract will be cancelled, discharge or what? Yes or no? Sorry? Yes. First, first we are seeing cases where there is no supervening impossibility. They will not consider that this is unexpected. What should not be unexpected impossibility? They are telling if it will, you are feeling that it is difficult to perform. You are feeling that my expenses, I am running more expenses. If you are feeling that I am not making good profit, these should not be the reason to not perform your duty. You will not be discharged by the contract in these cases. Like that, strikes, lockouts, civil disturbances or rights. In these cases also the duties will not, your obligation will not be discharged unless the contract specifically provides otherwise. If in your contract it is written, if there will be strike, if there will be rights, we will discharge the contract. ಯಾವಾಗ ಅರ್ಥ ಆಗತ್ತೆ ನೀವುಗೆ? ಇನ್ನೂ 3 ಚಾಪ್ಟರ್ ನಾನು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀವಿ. When you will know the interpretation of unless, when guys, huh? You said the same, okay, but first of all, what is written straight, you go straight. Don't apply your mind. These, what they are telling, these situation, don't discharge a contract. So in any case, you cannot say, you have to say first strike, lockout, civil disturbance, cannot discharge the contract, because that is the general rule. Unless, jab unless aa gaya aapka, then you have to add some other thing, right? So unless the contract specifically provides otherwise, if anything is mentioned in your contract, if strike will be there, rights will be there, we will discharge the duty, discharge the obligation, discharge the contract. Then only in these cases it will be discharged, otherwise it will not be discharged. Done? Yes? USD or not? Yes. So discharge by breach. Discharge by breach. What is breach, guys? Violating, breaking. Okay? Yes? Yes. So discharge by breach, two conditions are there: actual breach or anticipatory breach. Okay? A contract is discharged by breach when one party fails to perform his obligation or performs them defectively. Either they fails to perform or perform them defectively. Breach may be of two types: actual breach or anticipatory. Actual breach occurs when a party fails to perform the contract, when performance becomes due or performance it improperly. Okay, A had told to make B that in 6 months I will make your house. Okay, I will make a house for you in 6 months. Now 6 months expired and he had not made that. Means due date, what was the due date? 6 months. It expires now and he had not performed. Or what he had made? The house he had made all teda meda. Like the corona times, engineer came, no? That time they are making the house. We were getting very beautiful pictures that time. The house made by the corona past engineer. Without classes, they were passing the exam. So they were making, हाँ, तुम्हारा उसका टेरेस नीचे चला जाता था, वो ऊपर चला जाता, हाँ? बिल्डिंग को भी कोरोना हो गया क्या? नहीं, इंजीनियर को कोरोना हुआ था. So the engineer had made that kind of building. So say suppose the A had made the house, but how it had made improperly. It was not a proper house, how the B wants. Okay. So in this case, what will happen? He had breached the contract. Okay. So that is called the actual breach. Second is what? Anticipatory breach. Important. Anticipatory breach occurs before the time for the performance arrives. This is important, guys. Before. The 6 month is not happened before that breach happened. Are you getting? So anticipatory breach occurs before the time for the performance arrives. Okay. It may rise when a party expressly communicates his intention not to perform the contract. Before 6 months, A is telling, I am not going to make this house for you, this building for you. Are you getting? Yes. So A is telling before 6 months only, I am not able to make this. So he is telling he is expressing his intention not to perform the contract. Or a party does some act which makes performance impossible. Something A had done something, because of that now he will not able to make that. Okay, so that is called the anticipatory, guys, when he is expressly communicating that I don't have any kind of intention to make this building, because he is breaching the terms and condition of that contract. Second, A had done something like that now he is not able to perform, that the performance is impossible. Now in such cases, the aggrieved party may treat the contract as discharged and seek appropriate remedies under the law. Which party, guys? B. Aggrieved party may treat the contract discharged, because only the promisor said I am not able to do this, and something promisor had done, now he is not able to make that house. Okay, so now what happened? This B, the aggrieved party may treat the contract as discharged and seek the appropriate remedy. They can go to the court and they can ask for the damages. Okay, they can ask for the remedies. And under remedies, damages, fine, many things will come. We are going to see further. Okay, yes. The remedies for breach of contract. Now, which kind of remedy they will take, guys? When a contract is broken, means breached, when a contract is broken or breached, the injured, means aggrieved party, is entitled to seek appropriate remedies against the defaulting parties. In our example, who is defaulter? Who is defaulter, guys? A is defaulter. He is not able to make the building for B. Who is making building? A is making building within 6 months for B. Okay. So now, when a contract is broken, the injured party, who is injured party? B is the injured party, is entitled to seek appropriate remedies against the defaulting party, that is A. The remedy available depends upon the nature of the contract and the circumstances of the breach. In what circumstances defaulter had breached the contract, and what happened that he had not performed his contract. So, in case of breach of contract, the aggrieved party may resign the contract. Aggrieved party have all right to cancel the contract. Okay, cancel the contract and refuse further performance. Means what he is doing from the beginning, how it is becoming impossible. Say suppose A had done such kind of task, he is bringing material, wrong material, the whatever stuff he is using, it is, and the skill, the labor skill is also not good. From the beginning he is making the building in a wrong shape. Now it is impossible further to complete it. Now B is not ready to do that. So what we will do, we will cancel the contract. So the aggrieved party may resign, means cancel the contract and refuse further performance, that don't perform it, I don't want to take it. Second, the aggrieved party can sue for damages. They can go to the court and they can tell that this much of advance money I had given and this much of my time wasted, for that I am claiming this much of damages. Then sue for specific performance, guys. Do you know specific performance is what? Particular performance. Say suppose A is making a building, but below, like he is making the double story and single story is there. Now what A had done? A had done something, that builder had done something which was damaging the single story also. Now B will tell, I am going to resign this contract, but first you correct my this. So that is called the particular or specific performance. Seek an injunction. Injunction is what? Stay order. B, promisee can go, or aggrieved party can go to the court and say, tell this person to stop this. I don't want it to take his performance further. That is called the injunction. Stay order. Okay. Injunction is what, guys? Stay order. Now sue on quantum merit. What is quantum merit? Quantum merit is what? Now guys, they had fixed, say suppose 25 lakh rupees to make that building, 25 lakhs rupees within 6 months. Okay. Now 2 months work he had done. Okay. And 2 months work that person had done. And now he is telling I will not perform. Okay. Now some advances B had given to that person. Now what happened? Quantum merit. Now the no fixed price is there for this much of work you will do. This much of money will be there. It is lump sum amount they had fixed. Okay. Now B had given some money to A. Now what happened? He had done some work. Now how much B can claim? Is there any fixed price of that? It is not. So if you can quantify, so they will go to the court and court will quantify the reasonable amount. Quantum merit क्या होता है? Reasonable amount when the price is not set, guys. When price is not set. There is no set of the price, no fixing of the price. When you are not able, he had made this much of work, how much you will pay to that? And how much you will cut, how much you will claim for the damages or what? Okay, say suppose he has destroyed your single story and he had destroyed, while making the double story, he had destroyed your single story. Now how much you will quantify that? You tell. How much you will tell? So when you are not able to decide that quantity of amount, you will go to the court and court will decide that reasonable amount and that the A have to pay to B. Are you getting? Yes. Then the discharge of duty will be happen. Okay. So that is called the quantum merit, a reasonable amount decided by the court for the damages. It's okay. So in case of breach of contract, the aggrieved party may resign the contract, refuse further performance, sue for damages, sue for specific performance, seek an injunction and sue on quantum merit. Done? Yes. So another 5 minutes, 6 minutes are left and there is a new topic we have to start, that is contract of indemnity and guarantee, guide. Section 124 to 147. Meaning of indemnity is what? So tomorrow probably I will not have class, but in the next class I am going to take from you how much we had covered in contract. In the next class we are going to take mega quiz and for the offline student test also. Okay. Okay. Yes. Okay na. So this much you have to do. Then your new topic will start, contract of indemnity and guarantee. What is indemnity? What is indemnity? If A and B is coming into the contract, if A and B is coming into the contract and A is telling to B that I am indemnifying you, I am taking an undertaking, I am indemnifying you, that if any losses happened because of me, means indemnifier. A is the indemnifier and B is what? बताओ. Chalo. A is giving a guarantee to B that if anything happened because of me or any other party, and if you will suffer the loss, I will make this loss, I will make the good, I will make good this loss. Okay, means what? Any loss if you will suffer, I will make it perfect. Means I will bear that loss because of him also and because of the other party also. And that is called the contract of indemnity. Okay. Now the word you had not given, guys. That word you had not given. जो इतना कॉन्ट्रैक्ट पढ़ लिया, कुछ तो लीगल टर्मिनोलॉजी निकालो. प्रोमिसर, प्रोमिसी. अरे वेयर इट वेंट. Okay, sufferer. Acha, sufferer. Or what more? Sufferer. Another 3 minutes are there. Yes. Sufferer. Or kuch. Anything else? Did you get this concept first? Indemnifier had said to whom? That is the question. To whom? Yes. So that if any losses will happen during this contract because of me or other party, I will make that loss good. Okay. Yes. Sure. That is the guarantee में आता है surety. Surety is there in the guarantee. Next concept. Who is it? क्या कर दे इसको? X कर दे क्या? X कर दे. But if in future your exes will have some losses, you will say, you are my ex. You are my ex because of me if you suffered losses, or after me, if you are choosing someone, that person will also make some losses. I will indemnify you. Yes, yes, yes. Yes. How you? No, no, no. You are giving an indemnity to someone. If you are making X here, then what will happen is let them suffer. Let them suffer. Huh? Sufferer. Hey, if this kind of guarantee you will give to your ex will be very happy. Like after you, they can explore many people. Because you, yeah, definitely. Like, means explore the relationship because you are there to take care of that. If any losses they will suffer, you are taking a guarantee. He said yes. किधर से चुराया? So it can never be X, right? है ना? X नहीं हो सकता ना? So this person is indemnity holder. This person is indemnity holder. Okay? Which we are going to discuss in the next class. Thank you so much for the patience listening. Call to our admin, madam. Call to our admin, madam. Where she has done. Yes. Hmm? Done?